Hello, welcome to the A Book a Day channel. This issue is dedicated to interpreting the book on crimes and punishments. Have you ever pondered the issue of the death penalty? To date, over 100 countries have explicitly abolished all forms of capital punishment. What philosophical underpinnings led to the abolition of the death penalty? To answer this, we must trace back to the famous Italian jurist, Beccaria, who was the first scholar in human history to propose the abolition of the death penalty. In the 18th century, the era of Beccaria, punishments were extremely cruel, and the death penalty was arbitrarily applied, with many minor crimes resulting in capital punishment. As a result, Beccaria thoroughly criticized the criminal law system of his time and vigorously advocated for humanitarianism. His book, written in 1764, on crimes and punishments, marked the beginning of the movement to abolish the death penalty. Even today, the arguments used by advocates of abolishing the death penalty have not surpassed the ideas proposed by Beccaria over 200 years ago. Of course, Beccaria's ideas did not emerge out of thin air. They bore the imprint of the Enlightenment movement of his time. So, what is the Enlightenment movement? In the words of the academic superstar Kant, the Enlightenment is mankind's release from its self-incurred tutelage. The motto of the Enlightenment was "Dare to use your own reason." Therefore, rationalism and humanitarianism are the hallmarks of the Enlightenment, and they are also the most important keywords in Beccaria's work. On Crimes and Punishments is the embodiment of Enlightenment thought in the field of criminal law, which is why Beccaria's book was highly acclaimed by the leaders of the Enlightenment movement. Voltaire, then in his 70s, praised the author, a young man in his 20s, with the utmost respect, saying, "The author of this book is our brother, a benevolent genius whose outstanding work has educated Europe." Now, let's delve into the main content of this issue. I will introduce you to three important concepts of Beccaria, which still influence the criminal law systems of many countries today. They are the concept of abolishing the death penalty, the concept of establishing the basic framework of modern criminal law, and the concept that the purpose of criminal law is to prevent crime. Firstly, I'll discuss the important concept of abolishing the death penalty. On Crimes and Punishments was the first book in human history to systematically propose the abolition of the death penalty, thus inaugurating the movement to end capital punishment. Just a few decades after its publication, in 1786, the Grand Duchy of Tuscany in Italy abolished the death penalty, becoming the first nation in the world to do so. So, why did Beccaria call for the abolition of the death penalty? He put forth 4 reasons, which I will explain one by one. First, Beccaria believed that the state fundamentally has no right to use the death penalty, considering it an abuse of power. To understand this viewpoint, we need to first comprehend how the state is formed. In Beccaria's time, the prevailing view was that initially, individuals living alone in the world were very insecure. Under these circumstances, there was a need for people to unite for their safety. To live together, each person had to give up some rights, eventually forming the state. This is the concept of the social contract theory that was popular at the time. Thus, Beccaria argued that the state is not an entity that fell from the sky. It derives from the rights relinquished by the people. However, the key is that the rights people give up are limited, and life is a special right. At that time, it was believed that if individuals had no right to end their own lives, then the state could not possibly have the authority to take away life. Therefore, Beccaria first argued that the existence of the death penalty violated the social contract theory, constituting a typical abuse of power. Second, Beccaria stated that the death penalty does not achieve its intended effect and is utterly meaningless. What effect does the death penalty aim to achieve? In theory, it is to intimidate the public and prevent crime, a concept akin to killing the chicken to scare the monkey or making an example to deter others. However, Beccaria believed that the death penalty cannot prevent crime. He argued that what influences people is not the severity of the punishment but its continuity. What does this mean? Although the death penalty seems cruel, its execution is brief, and therefore, its impression on people fades quickly. Beccaria argued that, in contrast, life imprisonment is much more effective in preventing crime, as people can endure extreme but brief pain, but not prolonged suffering. Following this line of thought, Beccaria further elaborated that the death penalty not only fails to play a positive role, but also has a counterproductive effect. This is the third reason he opposed capital punishment. Human nature tends to sympathize with the weak, and the stark contrast of power between the state and the condemned on the scaffold creates a sense of injustice and pity, thus significantly diminishing the intimidating effect of the death penalty. Therefore, Beccaria stated that in many people's view, executions are more like a performance, intended more for the audience than the criminal. If the audience's sympathy outweighs other emotions, then the execution fails to achieve its intended effect. Lastly, even more alarmingly, the death penalty can make society increasingly cruel, leading to a vicious cycle of violence. Beccaria believed that capital punishment provides a brutal example and poisons the human spirit. The law prohibits murder, yet it publicly commits murder itself. The law prevents citizens from becoming murderers but arranges for a public executioner. Such practice is not only logically absurd but also completely undermines the justice of the law. The existence of the death penalty tells people that murder is permissible under certain conditions. This is why countries with more executions tend to have more brutal crimes. After discussing these 4 reasons for abolishing the death penalty, Beccaria also left a caveat, believing that the death penalty could be retained in very special circumstances. For instance, if someone's existence threatens the security of a nation or poses a risk of unrest, or when a nation falls into anarchy and chaos replaces law, then the death penalty becomes necessary. Let's summarize Beccaria's first concept. In a normal society, the death penalty should be abolished. The reasons for its abolition are fourfold. Firstly, Beccaria believes that the state has no right to apply the death penalty, considering it a typical abuse of power. Secondly, the death penalty does not prevent crime and is meaningless. It even has a counterproductive effect, as it invokes pity for the condemned. Finally, he argues that the death penalty can lead to a vicious cycle of violence in society. In addition to the concept of abolishing the death penalty, Beccaria's second concept is about establishing the basic principles of modern criminal law. The principles of legality and proportionality in punishment are almost universal in the criminal laws of modern countries. Over 200 years ago, Beccaria laid the groundwork for these principles. Firstly, no crime without law, no punishment without law is the most important criminal law principle in a legal state. Beccaria emphasized that only the law can define crime and punishment. Deeply influenced by the social contract theory, he believed that only the legislators of society could enact such laws. No other individual, whether a judicial officer or someone who considers themselves morally superior or just, has the right to impose punishments beyond the limits of the law. Beccaria stated, legislators cannot be both lawmakers and judges. The application of law must be in the hands of independent judicial officers. Judges cannot interpret laws arbitrarily, otherwise they become de facto lawmakers. Similarly, legislators themselves cannot legislate arbitrarily beyond the social contract. Remember what we just discussed. Beccaria considered the death penalty as exceeding the limits of the social contract. Returning to the original text, Beccaria also stated, law should be as clear and public as possible. The more people understand the legal code, the fewer the crimes. Ambiguities in the text are a major drawback. If the law is written in a language incomprehensible to people, then they are at the mercy of a few legal interpreters, unable to grasp their own freedoms. Beccaria's concept of legality clearly pays homage to Montesquieu. When Beccaria wrote this book, Montesquieu had been deceased for nearly a decade. However, Montesquieu's principle of the separation of powers had almost convinced all the great minds of Europe at the time. Montesquieu believed all those who have power tend to abuse it. This is a perpetual and fundamental experience. People exercise power until they encounter limits. Later, the famous liberal Master Acton gave a more succinct expression. Power tends to corrupt, and absolute power corrupts absolutely. Therefore, it is necessary to limit power. An effective way to do so is to divide state power into 3 parts, legislative, judicial, and executive powers, held by 3 different institutions to maintain a system of checks and balances, avoiding power becoming despotic and corrupt. Clearly, Beccaria was implementing Montesquieu's ideas in the field of criminal law. Having discussed the principle of legality, let's look at the other principle of proportionality in punishment, meaning severe punishment for serious crimes and lighter punishment for lesser offenses. Although this seems simple, it is quite profound. Beccaria believed that as long as the evil of the punishment outweighs the benefits of the crime, the punishment can be effective. Therefore, the criminal law must be firm, ensuring punishment for crimes, but not excessive. Crime is an evil, and punishment is also an evil. Using evil to counter evil is like using poison to fight poison. But the poison should not be too strong. It is only necessary for detoxification, not to kill. Deeply influenced by rationalism, Beccaria thought it best to design the relationship between crime and punishment like geometry, creating a sophisticated ladder of crime and punishment. From the most severe to the mildest crimes, from top to bottom, punishments should also be arranged in a corresponding ladder from severe to light. Both too light and too heavy punishments fail to achieve the purpose of punishment. Severe punishment for minor crimes can lead to more crime. Let's briefly summarize the author's second point, which proposed the two basic principles of modern criminal law, the principles of legality and proportionality in punishment. The principle of legality means that only the law can define crime and punishment, and Beccaria believes that legislators and judges must be separate, with legislators not legislating arbitrarily beyond the social contract. Additionally, Beccaria pointed out that legal texts should be as clear and public as possible. The other principle is the proportionality of crime and punishment, advocating for a geometric relationship between crime and punishment, with severe punishment for serious crimes and lighter punishment for lesser offenses. We can see that Beccaria's proposals for abolishing the death penalty and establishing basic principles of criminal law both point to his views on the purpose of punishment, which is the third important concept in his book. Beccaria believed that the purpose of punishment is to prevent crime. Throughout human history, there have been two views regarding why punishment is necessary. One view is that punishment is needed because of the existence of crime, while the other view holds that punishment is needed to prevent crime. The difference between these two views lies in their focus. The former looks to the past and can be termed retributivism, which is about retribution for crime, exemplified by the common sayings life for a life and paying back debts. The latter, however, focuses on the future and aims to reduce future crimes through the application of punishment, known as preventionism. Beccaria was strongly opposed to retributivism. He argued that the purpose of punishment is not to torture or destroy, nor to erase a crime that has already been committed, but simply to prevent the criminal from reoffending and to deter others from following the same path. The legal philosopher Jeremy Bentham later gave more precise names to these ideas, calling them general prevention and special prevention. General prevention is about deterring the general public from committing crimes, while special prevention is about depriving criminals of their ability to reoffend. For instance, castrating child sex offenders using chemical substances to remove their sexual abilities is an example of preventionism. Beccaria believed that preventing crime is more enlightened than punishing it, and this is the main purpose of all excellent legislation. His opposition to the death penalty also stems from his belief that it does not prevent crime. Beccaria thought that punitive measures are only a small aspect of crime prevention. Apart from punishment, there are many other methods that can be used collectively to prevent crime. For example, laws should be made more clear and accessible, establishing the authority of the law, making it worthy of respect, and ensuring people respect the law out of a healthy mindset rather than out of enslavement. At the same time, law enforcement agencies must also focus on adhering to the law and not become corrupt so as to earn public respect. Additionally, the most reliable and difficult measure to prevent crime is improving education. Education can guide young minds towards morality and prevent them from straying onto the wrong path. In summary, the author's third point is that the purpose of punishment is not to retaliate against crime, but to prevent it. Apart from punishment, he advocates using various methods collectively to prevent crime. For example, laws should be formulated more clearly and accessibly, while law enforcement agencies should focus more on adhering to the law. Finally, the most reliable and difficult measure is improving education. Part 4. These are the three most important concepts in on crimes and punishments. How should we evaluate this book? Firstly, it is indeed a great work. No praise is too strong for this book. Beccaria's three ideas greatly influenced subsequent criminal legislation and profoundly shaped human thought. Many countries invited Beccaria to reform their criminal laws. After reading on crimes and punishment, Catherine the Great of Russia was so excited that she invited Beccaria to Russia to help her reform the criminal law. When Austria, where Beccaria was based, saw that Russia wanted to take him away, they immediately offered the best terms to keep him. Beccaria later participated in the drafting of the Austrian Penal Code, which was the first in human history to stipulate the principle of legality and punishment. As for Beccaria's concept of abolishing the death penalty, it continues to influence the laws of various countries today. Beccaria also greatly influenced later thinkers, such as the British utilitarian philosopher Jeremy Bentham. What do you know about Bentham? Of course, it's his saying, the greatest happiness of the greatest number. But this phrase was actually said by Beccaria. In the introduction to On Crimes and Punishments, Beccaria wrote, "If one thinks rationally, the only purpose in enacting law should be the greatest happiness of the greatest number. The greatest happiness of the greatest number can be seen as Bentham's lifelong motto," and he continued on the path opened by Beccaria. Beccaria focused on criminal law, while Bentham's reform plans encompassed all areas of law. However, On Crimes and Punishments also has its limitations. For example, Beccaria attempted to design the relationship between crime and punishment with geometric precision and believed that the purpose of all legislation is the greatest happiness of the greatest number. Bentham also used this principle to evaluate the rationality of all laws. However, this thinking cannot avoid the tyranny of the majority over the minority, as the tyranny of the majority is inherently rationalized. More dangerously, rationality cannot provide a precise definition of greatest happiness, and this abstract concept becomes an excuse for the few to seek personal gain, often representing the majority. Let's take an extreme example. According to Nazi ideology, wasn't the genocide of Jews carried out for the greatest benefit of the majority of the German people? As for Beccaria's concept of abolishing the death penalty, it certainly reflects the great light of humanitarianism, but it can also go in the opposite direction. The old saying goes, "A life for a life is the natural law," but rationalism believes that nothing is naturally justified and everything should be subject to rational assessment. This arrogant rationalism, which believes in the omnipotence of human reason, laid the groundwork for later disasters. For example, Beccaria advocated using punishment to reform criminals, which is what we previously referred to as special prevention. Following this line of thought, later people believed that criminals are merely sick and need treatment. Thus, punishment became treatment, and serving a sentence became receiving medical care. Do you see the problem? Whether a behavior should be punished has moral implications, so the public can have a say. But when we replace the concept of punishment with prevention and correction, only experts can make judgments. In other words, whether a murderer or child molester is guilty is a matter for the public to decide, but whether someone is sick is up to the experts. Thus, humanitarianism shifted the trial from judges to experts. The public's basic sense of justice has the right to criticize judges, but they are powerless against these experts. So, what is the ultimate outcome? If a behavior unacceptable to mainstream society occurs, even if it has nothing to do with moral guilt and should not be deprived of freedom, the state can still treat it, and others cannot argue, because the experts didn't say these people committed crimes, only that they were sick. They are not taken to prison but to hospitals for treatment. For example, during the Nazi era, many criminal law scholars, under the guise of humanitarianism, labeled any behavior that displeased the government as a disease and subjected them to compulsory treatment. After discussing special prevention, let's talk about general prevention, which is using punishment to deter the general public. We also need to be cautious about this view. If the legitimate basis of punishment is not a person's past crimes but effective prevention, then there is no need to consider whether the punished individual actually committed a crime. For the sake of deterrence, arbitrarily choosing a scapegoat fits the logic of general prevention. Summary. That concludes the content of this issue. Let's summarize. Beccaria's On Crimes and Punishments proposed three great ideas. The most important, of course, is the abolition of the death penalty. The state has no right to apply the death penalty. It is meaningless and fails to serve its intended purpose. On the contrary, the death penalty can backfire, eliciting sympathy for the condemned, diminishing the effectiveness of punishment, and, more alarmingly, poisoning the human spirit, making people crueler and leading to an increase in crime. Secondly, Beccaria established the basic framework of modern criminal law principles, the principles of legality and proportionality in punishment. Only the law can define crime and punishment, and the provisions of the law should be as clear as possible, minimizing the possibility of judicial interpretation. Both legislative and judicial power should be strictly limited. Lastly, we discussed Beccaria's view that the purpose of punishment is to prevent crime. He believed that the purpose of punishment is not to torture or destroy, nor to erase a crime that has already been committed, but simply to prevent the criminal from reoffending and to deter others from repeating the same mistakes. In the conclusion of On Crimes and Punishments, Beccaria wrote the following passage, summarizing these three important concepts. In order not to make punishment an act of violence perpetrated by one or some against other citizens, punishment must, by its nature, be public, prompt, necessary, the least possible in the given circumstances, proportional to the crime, and determined by the law. That's all the essence of the book for you. I hope you enjoy it. Congratulations on completing another book.